essentially have a complete view of his movements and what he's doing at that point in time.
Yes.
And you never saw him during that time period before you got out of your car and reached for any weapons or anything like that?
No.
Were there other individuals around the traffic stop other than the defendant and the driver?
Not that I can remember.
Do you recall anyone walking through the scene and asking about the restaurant next door?
I don't remember that.
On March 15, 2023, Jose Chile Diccastro was arrested on charges of obstructing and resisting a public officer. Mr. Diccastro is a well-known YouTuber as a First Amendment auditor and activist against police abuses. In his channel, Delete Laws, he shows videos of filming police encounters, commenting on constitutional rights, and criticizing what he considers misconduct by authorities. On the date of his arrest, Mr. Diccastro approached and started talking to a driver who was being addressed by a police officer due to an alleged traffic violation. Officer Brandon Bork ordered Mr. Diccastro to step back to ensure the safety of the approach, allowing him to continue filming as long as he maintained a safe distance. According to Officer Bork, Mr. Diccastro refused to move back as requested by the officer. Mr. Diccastro also used profanity to the officer, which after he used them, the officer approached to conduct his arrest. Following nearly a year of legal maneuvers and delays, the case proceeded to a bench trial on March 19, 2024, before Judge Ann Zimmerman in the Las Vegas Justice Court, Nevada. During the trial, after Officer Bork answered the prosecutor's questions on direct examination, Mr. Diccastro's attorney, Michael Mee, had the opportunity to cross-examine him.
Good morning, officer. How are you doing?
Good morning, sir. I'm well. How are you?
Very well. How many feet did you order the defendant to back up specifically?
I never had an opportunity to give him an exact distance.
How far back did you intend to have him back up, even if you didn't express that?
In the background of the video, you could see that there was a parked semi-truck and a light pole. I would have directed him somewhere in that area, which would have been outside the 21 feet.
Your testimony is you never told him an exact distance to back up, correct?
Yes, he never allowed me to.
What do you mean he never allowed you to?
I asked him to back up, and he continued arguing with me, so I could never specify the exact distance for him.
But you had time to give him 5 commands to back up, is that correct?
Yes.
Your testimony is he never backed up when you were giving him commands, is that correct?
If he backed up, it may have been inches, but he didn't substantially back up.
And you just reviewed the body-worn camera from your chest, is that correct?
Yes.
Okay. You didn't notice him backing up every time you directed him to back up?
He did not back up.
So you backed up 0 feet, in your opinion? Based on that video?
Not 0 feet.
What was that?
He didn't back up 0 feet. He was moving his feet. As to exactly how far he moved back, I don't know, but it wasn't substantial.
What would have been substantial in your opinion, or what do you mean by that?
I would have guided him if he wasn't arguing with me back toward the light pole and the parked semi-truck.
And
Would have been outside of the 21 feet. That was my goal.
So in your opinion, you have the ability, or you would in any traffic stop, ask somebody to move back 21 feet, is that correct?
Yes, for our training.
And what was that training?
That while we're conducting lawful activity, we're allowed a reasonable distance to conduct our activity.
But where do you get that 21 feet number from specifically?
That's taught to us in the academy. It's based on reaction time, normal human reaction time to a threat.
So your position is anytime you're engaged in any law enforcement activity, you would create a 21 feet perimeter?
Not necessarily. It depends on other environmental factors such as obstacles and barriers.
So your testimony is that every time you conduct a traffic stop, as long as there's no barriers, you would order a pedestrian to back up 21 feet, is that correct?
I would, yes.
Mr. Mee impeaches Officer Bork by pointing out the conflict between his testimony that Mr. Diccastro was interfering with the stop and the lack of specific articulable facts showing a physical obstruction. Impeachment is the process of challenging a witness's credibility, which can be accomplished by showing that their story has changed or is inconsistent with the evidence. Under Nevada Revised Statute 50.135, a witness's prior statement or current testimony can be challenged when it lacks consistency. According to Officer Bork, Mr. Diccastro was obstructing his duty as an officer, as shown in the body cam video. Under Nevada Revised Statute 197.190 defines obstructing a public officer as willfully hindering, delaying, or obstructing an officer in the discharge of their official powers. But Mr. Mee objected to the obstruction, pointing out that Mr. Diccastro gave more space to the officer and claimed that 21 feet would be an unreasonable amount of space as solicited by the officer, a distance not codified in Nevada law. By highlighting that the officer could still perform his job despite the allegedly lack of space, Mr. Mee sought to undermine the officer's credibility regarding the lawfulness of the arrest.
What training do you have in regards to the First Amendment?
It's standard academy training.
Can you explain what that entails?
Usually includes a classroom setting, PowerPoint taught by a police officer, academy officer.
Do you remember receiving that training specifically?
Yes.
How long ago was that?
When I was first employed about 8 years ago.
Do you have any follow-up training?
Specifically on First Amendment, we've had some follow-up training regarding First Amendment auditors.
Okay, can you explain what that follow-up training was?
The follow-up training was just a refresher on the First Amendment and how the department wants to handle or react to First Amendment auditors.
In that training, did they explain any case law governing how many feet somebody has to move back or anything like that?
Objection, Your Honor, at this point of relevance. I think it's beyond the scope of, the charges that you are to determine guilt on at this time.
Can you tell me what's the relevance?
Yes, Your Honor. He detained the defendant after issuing commands back up a particular distance. He's testified he's received training. I should be entitled to cross-examine him about what that training is and how he's coming up with the specific numbers he's using to
I think her objection was with respect to the case law that you're inquiring about.
Your Honor, our position is if he is issuing commands that are contrary to that case law and he's been trained on that case law, then there can't be an obstruction of justice.
So I'm going to sustain the objection and ask you to move along.
Have you had any prior issues enforcing the First Amendment?
No.
Prior to this event taking place, had you heard of Jose Diccastro?
No.
Do you recall when you first heard about First Amendment auditors specifically?
Go for it.
It would have been in the academy.
So that was when you were first trained? You had heard about the auditors back then?
Yes, when we were learning about the First Amendment, they would typically bring up issues that might be a frequently seen thing. And First Amendment auditors are typically the ones that we encounter when there's First Amendment claims against us.
Do you have any belief that First Amendment auditors are likely to be violent?
Objection, relevance.
What's the relevance?
Uh,
I'm only concerned with Mr. Diccastro. Okay.
Your Honor, one of the legal issues at question here is whether or not these commands are reasonable. I think that has to be based upon his past experiences in training.
Sustain.
Mr. Mee asked Officer Bork which training he had on the First Amendment right. Under the First Amendment, citizens have a clearly established right to record police officers performing their duties in public spaces, a right that serves as a critical check on government power. In the case of Mr. Diccastro, the defense argues that this constitutional protection is the starting point for any analysis of his conduct. Under the Supreme Court's holding in City of Houston versus Hill, the court emphasized that the First Amendment protects a significant amount of verbal criticism directed at law enforcement. The court noted that the freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. Therefore, unless Mr. Diccastro's speech constituted fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace, his verbal conduct is constitutionally immunized. The prosecution's claim that filming is not a license to interfere fails if they cannot prove a physical nexus of obstruction. Without a physical act that actually prevented the officer from performing a specific duty, the arrest constitutes unconstitutional First Amendment retaliation.
During this traffic stop in particular, what specific factors led you to believe there might be a danger to officer safety?
Based on his proximity to my driver, based on his demeanor being argumentative, based on his physical demeanor, his veins were popping out of his neck as he was yelling at me.
You could see his veins popping out of his neck from your back where your vehicle is?
When I was at the driver's side window, I could see that, but not in my car.
So when you see him walking out from your car, what is your specific concern regarding officer safety at that point in time?
Well, it's my safety and the safety of the driver. I don't know who this person is. I've never met him before. He could be peaceful, he could be violent, I just don't know. There's so many unknown factors. And I also have a responsibility to protect that driver. If I were in that driver's position, I wouldn't want to be approached by some random person recording me, interviewing me.
Did you ever ask the driver their opinion about whether they wanted him there or not?
No, my first step was...
relevance.
Sustained.
Was your primary concern him speaking to the driver or him not backing up allegedly?
My primary concern was safety. I don't know if he was armed or what his intention was.
Do you presume someone is armed and dangerous just because they're in public?
I can't rule out that he's unarmed.
But you had no reason to believe he was armed on this occasion?
No, nobody had told me he was armed, and I didn't see any weapons visible, but he was wearing clothing that could have easily concealed weapons.
So when you first came upon the scene, you were in your vehicle typing on your computer, is that correct?
Yes.
And what were you doing in relation to that traffic stop at that point in time?
Conducting a background check to see if her license was valid, to see if she had any criminal history to help me make my decision whether to warn her or issue citation.
You stated your belief that the driver was entitled to privacy.
I did say that.
And what do you mean by that?
Instead of continuing to give him commands to back up, I said something different to try and help him understand. She's really not entitled to privacy, but she's entitled to safety.
So your explanation is that you said that because you were just trying to convince him to back up, not because you believed?
Yes, if I continue to give the command to back up and he's not listening, I can't expect something different to happen if I just keep saying back up.
In your police report, do you recall referencing the fact that he had due notice in your opinion of what you were commanding him to do?
Yes, when I gave him 4 commands to back up, those due notice.
Okay. But you'll agree with me, he did not have notice as to the distance you wanted him to back up, is that correct?
That's correct.
Mr. Mee asked Officer Bork about Mr. Diccastro's behavior in the interaction. Mr. Diccastro claimed that his refusal to move was based on his understanding of Nevada law and his right to record a traffic stop from a public area. Under State v. Glean, the defense argues that a citizen is not required to obey an order that lacks a lawful basis, particularly when that order interferes with a protected constitutional activity in a traditional public forum. In response, Officer Bork invoked the officer safety doctrine, testifying that his primary mandate was the security of the scene. The officer characterized the immediate vicinity of the stop as a work zone, asserting that any third-party presence within this perimeter created a per se safety hazard. However, the defense contends that safety cannot be used as a broad-spectrum pretext to move a journalist or bystander who is not physically interfering. Under the least restrictive means test, if the officer could have performed his duties while Mr. Diccastro remained at a reasonable distance, the order to retreat further was an unconstitutional unconstitutional overreach rather than a valid safety protocol.
At any point during the, I guess, detention of the defendant, did you pat him down to determine he didn't have any weapons?
I did.
Okay, and when was that during the duration of the interaction?
That was immediately after handcuffing.
Okay, did you discover any weapons on him?
No, I did not.
From your police car, while he's walking up, you can essentially have a complete view of his movements and what he's doing at that point in time.
Yes.
And you never saw him during that time period before you got out of your car and reached for any weapons or anything like that?
No.
Were there other individuals around the traffic stop other than the defendant and the driver?
Not that I can remember.
Do you recall anyone walking through the scene and asking about the restaurant next door?
I don't remember that.
But your testimony is if there was someone else on the video, you would have been ordering that person to back up 21 feet?
I would have first asked them to back up, and most people do. And then if they did not comply, then I would give them a specific area to back up to.
You ordered him not to speak to the driver, is that correct?
Yes. Well, I remember asking him to back up. I don't remember if I specifically asked him not to speak to the driver. I think I may have said don't talk to her or something to that effect.
Did he speak to her before you got out of your patrol vehicle or afterwards?
Before. I saw Diccastro filming. I stayed in my vehicle and continued my business. Then when I saw him speaking to the driver, that's when I exited.
Did you see him speak to the driver after you exited the vehicle at any point?
I don't remember if he spoke to the driver after I exited.
At any point, did you hear specifically what he may have said to the driver?
No, I was too far away and it was windy.
Is your position that anytime you're engaged in a traffic stop, nobody can speak to the driver?
They can speak to them at a reasonable distance.
And is that 21 feet?
It could be shorter, it could be longer. Again, depends on the environment, totality, the circumstances.
Do you think people can easily verbally communicate at 21 feet?
No, not without shouting.
According to Officer Bork, he only approached Mr. Diccastro when he started to talk to the driver in the car. Officer Bork reinforces that he asked Mr. Diccastro multiple times to back up, but Mr. Diccastro stated that he was in his rights to film and talk to the driver. Under Nevada Revised Statute 171.123, an officer may detain a person if circumstances reasonably indicate that the person has committed, is committing, or is about to commit a crime. Mr. Diccastro argued that because he was only filming, there was no reasonable articulable suspicion of a crime. Therefore, the demand for ID was unlawful. The officer countered that the obstruction was the crime in progress, which then triggered the legal requirement to identify. On the same day, Mr. Diccastro was found guilty on the charges of obstructing a public officer and resisting a public officer. While the prosecutor originally suggested a suspended sentence in impulse control classes, Judge Zimmerman handed down a penalty of 180 days detention in the Clark County Detention Center in immediate remand. The judge cited Mr. Diccastro's behavior during the trial as evidence that he intended to get arrested to boost his YouTube channel's views. Mr. Diccastro's attorneys filed a criminal appeal before the Clark County District Court in Nevada. On July 10, 2024, Judge Michelle Levitt in the 8th Judicial District Court in Clark County, Nevada, held the final appeal hearing, where she ruled that Diccastro's conduct was protected by the First Amendment and ordered his immediate release after approximately 100 days in jail. On May 15, 2025, leveraging this appellate victory, Mr. Diccastro initiated a civil rights action under 42 U.S.C. Section 1983, alleging false arrest, First Amendment retaliation, and due process violations by the county and the court. As of February 2, 2026, the litigation remains active, with Clark County filing a motion to dismiss, asserting various forms of immunity and arguing that the initial arrest was supported by probable cause despite the eventual reversal. Our next case occurred on August 16, 2019. Defendant Eddie Hall stood trial in Hardin County District Court on 6 criminal charges, including operating a motor vehicle under the influence, obstructing governmental operations, and failure to maintain required insurance. The charges stemmed from events that occurred on August 31, 2018, when Officer Ben Norris of the Kentucky State Police observed the defendant's vehicle at a gas station on Rogersville Road. Officer Norris initiated contact with the defendant after allegedly witnessing evasive driving maneuvers and a subsequent traffic violation involving the vehicle crossing the center line. During that encounter, Officer Norris noted the smell of alcoholic beverages and physical signs of impairment, which led to a DUI investigation ending up in his arrest. The first witness called by the defense was Mr. Hall's friend, Timothy Aaron Lewis, who was in the passenger seat on the day of the event. In his testimony, Mr. Lewis affirmed that the alcohol in the car was his. Later that day, Officer Norris was called by the prosecution. After the direct examination, the defendant's attorney, Larry Foreman, had the opportunity to cross-examine Officer Norris.
How long has it been since you completed your DUI training?
Like I said, sir, I believe I completed it in October 2016.
So about the same time, almost 3 years?
Yes, sir. Identical to, like I said, Officer Batcher.
Mm-hmm. You wrote the citation in this case, correct?
Yes, sir.
So let's talk about the events that transpired on September 15th, shall we? You have arrived on scene around 12:32, according to your citation. Does that sound
Correct.
fair?
Yes, sir.
And Officer Batcher was already on scene when you arrived.
Correct.
Officer Batcher has already made contact with the vehicle's driver,
Yes, sir.
which is Mr. Hall.
Yes.
And I don't believe you testified to that, but Officer Batcher did. He had a passenger in his car,
Yes.
right?
Yes.
Did you talk with the passenger?
No, I did not.
Were you aware that the passenger was drinking?
At the time, no, but since then, yes.
And you were aware that he had an open container with him?
I don't recall.
When you write citations, part of your training at the academy was to make them complete,
Yes, sir.
accurate,
Yes, sir.
truthful,
Yes.
and that is because we're going to rely on it at some point, right?
Yes.
A prosecutor is going to rely on it.
Yes.
I would rely on it.
Yes.
The judge would rely on it.
Yes.
And the jury would rely on it, right?
Yes, sir.
Did you complete any supplemental reports other than the uniform citation in this case?
Just what I have.
So you have memorialized the events that have occurred in these 2 sheets of paper. Is that a fair statement?
Yes.
You ever heard the phrase in your training, I believe, I'm not sure if I'm quoting it exactly, but remember, if you didn't write it in your report, it didn't happen. Do you
Yes.
remember that in the training?
Yes.
Why do they teach that?
They tell us to paint the bear in the academy. And ultimately what that means is all the events that take place, if the officer can, to the best of his ability, will put it in their citation. Paints the bear.
So in your citation, you have noted the observations of Officer Batcher as well as your own, correct?
Correct.
You stated that you also came into contact with the above subject at some point, correct?
Correct.
And you testified that you could smell an odor of alcohol coming from his breath and his vehicle, right?
That's correct.
And when you asked Mr. Hall if he had been drinking, he stated, "No, I have not."
Correct.
And you have no capitalized in your citation.
Correct.
Is it because he made an emphasis on it?
Yes. Usually when I use that, it's what the individual states. Like, no, I did not. That's what he stated.
Right, I'm asking you, why is the no capitalized? N-O. Both letters are capitalized.
Oh, I don't recall, I'll be honest with you.
Would it be a fair statement that he probably made an emphasis on that no?
Potentially, yeah.
I mean, you wrote the citation. That's why I'm asking.
I'm well aware I wrote the citation.
Was it you who collected his Mr. Hall's documents, the license, registration, proof of insurance?
No.
During cross-examination, Mr. Foreman systematically dismantled the arresting officer's credibility through impeachment by omission. Mr. Foreman highlighted the material discrepancy between the officer's trial testimony, claiming a direct odor of alcohol on the defendant's breath, and the official report, which documented only a general odor within the vehicle. By emphasizing the officer's failure to establish a particularized suspicion that distinguished the driver from his passenger, Mr. Foreman challenged the legal sufficiency of the probable cause for arrest. Ultimately, this characterized the officer's testimony as a post hoc embellishment. By demonstrating that the officer's citations lacked these critical observations, Mr. Foreman moved to suppress the reliability of the evidence, framing the arrest not as a documented investigation, but as an unsubstantiated fishing expedition.
You've indicated in your citation that his eyes were bloodshot and glossy, right?
Correct.
You're aware that a very common indicator of impaired drivers is slurred speech, right?
Yes.
And he did not have any slurred speech.
No.
He did not have a red or flushed face, correct?
Correct.
Which is commonly accompanying bloodshot eyes, right?
Correct.
Because the alcohol expands the vessels in the blood, right? The blood
Correct.
begins to flow. So that was an incongruence, right?
Correct.
When you asked Mr. Hall out of the vehicle, you have stated that he was very unsteady on his feet and could not keep his balance, right?
Correct.
As you were administering the horizontal gaze nystagmus, he did not sway,
Correct.
he did not fall over,
No.
he did not throw up,
No, he did not throw up.
he didn't stumble,
No.
he didn't lose his balance as you were performing the HGN test,
Correct.
he was not leaning against his car,
Not that I can recall.
he was respectful when he spoke to you,
Yes.
he didn't swear
No.
or cuss you out.
No.
And you've already testified that you performed the horizontal gaze nystagmus test, was the first test, right?
Before I performed the horizontal gaze nystagmus, I checked for the medical exemption of that, the PRE, this equal pupil size, arresting nystagmus, and equal tracking.
I'm sorry, I usually lump them together as part of, because I believe they're in the same chapter, the HGN chapter, so in my head they're kind of like
That's fine.
part of the HGN test. But I understand where you're coming from. So before you perform the actual looking for the clues, if you will, you found that he had equal pupil size, the pupils were equal, the size was equal, and the tracking was equal, right?
Yes, sir, that's correct.
And you also check for resting nystagmus,
Excuse me, yes.
right?
Yes, sir.
And if there was resting nystagmus, that could indicate potentially that a person is heavily under the influence,
Or it could be a medical problem.
or a medical problem.
Yes, sir.
With respect to alcohol, it would be somebody who's quite intoxicated.
Heavily intoxicated.
And then Mr. Hall did not have resting nystagmus.
No, sir, he didn't.
Do you recall Mr. Hall stating that he has an astigmatism?
No, sir.
Are you aware that nystagmus can occur for a variety of reasons other than alcohol and other than just a simple medical condition,
Yes.
like hypertension,
Yes.
high blood pressure?
Correct. I also have taken a advanced class, A-RIDE class for impairment, advanced roadside impaired driving enforcement, that indicates different types of nystagmus, drug-induced nystagmus, stuff like that.
So you've learned what type of nystagmus to look for.
Correct.
Are you an ophthalmologist, Officer Norris?
No, sir.
Are you an optometrist?
I'm no doctor at all, sir.
Not an eye doctor?
No, sir.
You don't have any medical training?
No, sir.
Nothing to do with the eye?
No, sir.
You're aware that nystagmus can occur naturally in a human being?
Yes, sir.
Mr. Foreman neutralized Officer Norris's testimony by contrasting the officer's subjective impressions with the absence of National Highway Traffic Safety Administration validated physical indicators of impairment. The defense argued that the absence of a flushed face or slurred speech suggested the defendant's appearance was more consistent with environmental fatigue than chemical impairment. Mr. Foreman elicited an admission that the officer observed resting nystagmus, a condition frequently rooted in medical pathology rather than alcohol consumption. By highlighting the officer's failure to conduct a proper medical rule-out regarding the defendant's astigmatism, Mr. Foreman challenged the officer's qualifications. Under the Daubert standard, he argued that the officer lacked the foundational expertise to distinguish between pathological nystagmus and vestibular nystagmus caused by alcohol. Furthermore, Mr. Foreman highlighted the internal inconsistency of the prosecution's case. The officer claimed the defendant was unsteady, yet admitted the defendant's speech was clear and his complexion normal.
And after the horizontal gaze nystagmus test, you asked Mr. Hall to perform other tests which you refused to comply with, right?
Yes, sir. As stated before, I asked if you had any balancing problems. He stated no. I said, would you like to perform any balancing test? He said no.
At which point you placed him in handcuffs
Yes, sir.
and placed him in the back of your cruiser.
Yes, sir.
And he complied.
He complied.
He didn't offer any resistance.
None at all.
He didn't try to flee.
No, sir.
He was polite.
Yes.
Was very cooperative with you.
Yes.
Is that a fair statement?
It's a fair statement.
You have an option to ask an individual to submit to a breath or blood test, right?
It's breath, blood, or urine. That's correct.
You did not ask for breath in this case.
I did not.
You gave him the implied consent form to sign, right?
Yes. Like stated earlier, I don't recall if he signed it or not, but yes.
So if you didn't sign it, you didn't do your job properly.
Well, there's a lot of people who refuse to sign it, so that's not technically right.
Well, you've indicated earlier that there is a copy somewhere in either the prosecution's file or your file, you just don't know where it is, right?
Yes, sir.
You did not have a body camera on you
No, sir.
on September 15th.
No, sir.
Did you have an in-car camera?
No, sir.
After you took him to the jail, did you secure any Sally Port video?
I did not.
Any jail booking video?
No, sir.
Any video at all?
No, sir.
Any audio recording?
No, sir.
So there's no video or audio recording with you that you brought to court with you today, as far as you know?
That's correct.
And from the entire conversation with Mr. Hall, I believe you testified on direct, you remember one statement, right?
Yes, sir.
I should not have been speeding or reckless driving.
That's right.
You don't remember anything else?
No, sir.
No further questions?
Mr. Foreman further undermined the prosecution's case by highlighting the stark absence of objective forensic evidence and the defendant's affirmative consciousness of innocence. Mr. Foreman elicited an admission from Officer Norris that, despite the gravity of the charges, the Commonwealth failed to solicit any chemical or confirmatory evidence, such as a breathalyzer or blood draw, to scientifically validate the officer's subjective impressions. In the absence of body cam footage or corroborating physical data, Mr. Foreman characterized the state's case as a ghost investigation. This lack of a contemporaneous record creates a significant evidentiary gap that fails to meet the high threshold of due process. Furthermore, Mr. Foreman contrasted the impaired narrative with the defendant's remarkable compliance and composed demeanor. By highlighting that the defendant was processed without resistance and that the officer neglected to offer tests that could have served as exculpatory evidence, Mr. Foreman framed the investigation not as a neutral search for the truth, but as a result-oriented inquiry. On the same day, Mr. Hall was acquitted of operating a motor vehicle under the influence, obstructing governmental operations, and failure to maintain required insurance, but was found guilty of reckless driving and a fine of $100. These cases show how strongly the result of a trial can depend on how trustworthy a witness appears to be, and how far defense lawyers may go to cast doubt on that trustworthiness. During their cross-examinations, both defense attorneys directed the judge and the jurors' attention to several inconsistencies and inaccuracies in the officer's statements, highlighting the importance of police procedure and factual basis to an arrest. By pointing out these differences between the officer's earlier statements and their testimony in court, the defense lawyers persuaded the jury that the accounts could not be relied upon. Even though the first case started with a guilty charge, in the end, the jury found the defendants not guilty and dismissed the charges brought by the state.